federal judge this week is blocking President Trump's executive order to prevent migrants from seeking asylum at the U.S.-Mexico border. Let's get the read on this from constitutional law attorney and former federal prosecutor Katie Cherkasky. Thank you for joining us today. Katie, the judge said President Trump exceeded his executive authority. This judge, obviously just the latest in a string of judges to hand down this kind of ruling, but how do you see it?
Well, I think this decision, like many that we've seen very recently, is highly vulnerable on appeal. The Supreme Court has made it very clear that the executive branch, the president, has very wide discretion that is pretty much not subject to judicial review when it comes to matters of national security. And what President Trump did with this asylum decision was to say, until this invasion at the border, which is established by very competent evidence, has ceased, that is not going to be an option for folks. And he does have authority to do so, at least according to the Supreme Court. So I would expect that he will be vindicated.
So you mentioned the word invasion there. And, you know, so many of these executive orders have this heated language, but words have meaning. Obviously, invasion runs counter to the idea that somebody is coming to this country to seek asylum. Will language matter in these kinds of cases going forward when you have words like invasion, for instance?
Well, the reality is that the asylum system has been exploited for a very long time, and that's no secret. And so in terms of the long-term ability to come to the United States, which is something that we've always been very proud of, to be a place in this world where people can come and seek true asylum for reasons that they need to escape from their home country. Certainly that is something that I think that the president and we want to honor. But when we have to deal with an actual emergency that has been established over the past administration very clearly, the president does have the authority to make unilateral decisions that the judiciary cannot second guess in order to deal with that. So certainly there's going to be pushback because there has been this long-standing idea that you can come here and just say the magic word asylum. But right. For instance, when the president says that it's a national security interest, that word also has meaning, and it's something that the courts have to greatly defer to when reviewing the executive's actions in that respect.
Katie, I want to get your thoughts on this case, too. Another judge this week blocked the Trump administration from ending temporary protected status for more than 520,000 Haitian immigrants. Now, do you think that this ruling as well will be challenged?
Well, I think it's in the name itself. It's temporary protective status. Again, the statute gives very little discretion to the judiciary to second guess that. There are some procedural questions about the notice that is given before they can terminate that status. But ultimately, the deference that's going to be due to DHS and to the executive, I think the Supreme Court will uphold that. President Trump and the executive branch have, again, been vindicated time and again after these lower courts have tried to overturn basically immigration law from the bench and impose their preferences over the decision of the executive, who has that authority.
Well, we appreciate your expertise on all of these issues, and we thank you for joining us today. Katie Cherkasky, have a great holiday weekend.
Thank you. Same to you.
Hey, it's Will Kane. Click here to subscribe to the Fox News channel on YouTube. It's the best way to get our latest interviews and highlights. And click to subscribe to the Will Kane podcast for full episodes right now.